All right, good afternoon, everyone. Welcome to our webinar, Adjustment of Status for Afghan Nationals. I know folks are still coming into the webinar, but we're going to go ahead and get started since we have a lot to cover today. So welcome. We're so excited that you're here and to talk to all of you about this very timely and interesting and rich topic. My name is Elizabeth Carlson. I'm a supervisory senior attorney with Clinic, and I'm fortunate to be joined by three wonderful colleagues, and I'll let them introduce themselves. Why don't we start with Rebecca?
Hi, everybody. Thanks for being here today. My name is Rebecca. I'm a supervising senior attorney with Clinic, and I'm happy to presenting Afghan adjustment of status. And I am based in Columbia, South Carolina as well. I'll pass it to Corey.
Hello, good morning, good afternoon, everyone. My name is Corey Hansen. I'm a senior attorney here at Clinic, and I work remotely out of San Diego, California. And I'll pass it over to Sarah.
Hi, everyone. I'm happy to be here. My name is Sarah Gakenya Cleveland, and I work with JFCS East Bay in Concord. I do work remotely out of San Diego, but I'm in Concord quite often working with JFCS East Bay. So I'm happy to be here.
All right, so in terms of the logistics of the webinar, you are welcome to put questions into the Q&A box. I would just kind of let folks know that we do have a pretty large group today. So most likely, we're going to keep an eye on the Q&A box, maybe look for some recurring questions, but we're not going to be able most likely to individually answer all of the questions that come in. And I know folks are probably saying hello, introducing themselves in the chat. That's great. You can also use the chat. We're going to be asking for feedback throughout the presentation in terms of what are your recent experiences and procedures, practices in terms of filing adjustment applications for Afghans. So there will be points when we ask for your feedback, and you are welcome to use the chat to share your tips and strategies as well. Okay, so in terms of our agenda for today, we're going to start out with a presentation by Sarah discussing considerations for individuals who are eligible to adjust status based either on an asylum grant or an approved SIV petition, or potentially both. We're going to then dive into a discussion of the terrorism-related inadmissibility grounds and how they apply at the adjustment of status stage. We'll then discuss how to address polygamy and non-biological children, derivatives of a 45 application, and considerations for travel outside the United States. All right, so with that, I'm going to turn it over to Sarah to start her presentation.
Thank you so much, Elizabeth. So again, I'm happy to be here with you guys discussing a topic that I think is overwhelmingly coming up in our practice. I know for our office, we're seeing a lot more cases where clients are eligible for multiple forms of relief, which is a positive thing. We've spent so many months hoping that they could at least get re-parole or something. But now we're in this positive position where we have some clients that are eligible for both SIV and asylee adjustment of status. And so it's not easy to say which one is better. And that's not the aim of my presentation today, as both have their pros and cons. But what we can do as advocates and attorneys and legal representatives is advise our clients of those pros and cons and ultimately allow them to make the decision on what they prefer going forward. So let's go ahead and jump in. So who's eligible for SIV? We're going to start off with SIV because I think SIV is the one that most of us in the legal profession, I know myself, prior to starting to work with Afghans heavily in 2021, I didn't really know much about SIV, and many of us still don't know as much as we'd like to know about SIV. So I'm going to jump in and have more information on SIV. So who's eligible for SIV? These are U.S. Armed Forces translators, or people who've been employed by or on behalf of the U.S. government or in the ISAF, the International Security Assistance Force. And so I think what really is the turning factor is the eligibility requirements for SIV. And as they're distinct from other forms of relief. So one of the biggest requirements that I think differs from other forms of relief. Some of us who practiced other types of immigration law or worked in other types of immigration law might know this term very well, the inspected and admitted requirement for eligibility. And so SIV applicants are required for adjustment, are required to have been inspected and admitted as a non-immigrant or paroled. So either admitted or paroled, but the admission as a non-immigrant is a really key difference from a lot of other types of relief that we use more often with parolees who've entered from Afghanistan or other clients. And I think that's important to note that for this discussion, I'm going to be operating with the assumption that we're working with parolees, right? Because we're looking at people who are eligible for both asylum and SIV. And I think the vast majority will be parolees. But I do think it's important to note that there are other categories that we're seeing come up more often that I think it's important to put an eye to or pay a little bit of attention to, and those would be refugees who enter as refugees who may also be eligible for SIV. This inspected and admitted requirement may be an issue and something to look deeper into, as well as clients who come through the southern border, IWI clients or otherwise inspected clients who are placed into detention who are not paroled into the United States. And so this is a really important requirement for those purposes. But for now, I'm going to go ahead with the assumption that we're working with parolees who've been inspected and paroled. And so moving on to the next requirement, the requirement to not be subject to any bars to adjustment of status is one other key one. There's also the requirement to be physically present in the U.S. at the time of filing, to have an approved I-360 or an approved DS-157. I didn't put all of these requirements because there are so many, but of course they need to have their approved SIV, which is an approved I-360 or the DS-157. There needs to be a visa available. And then, as I mentioned, not subject to any bars or to adjustment of status. And this one we'll talk a lot about because that differs significantly from asylum. And then also to be admissible or eligible for a waiver of inadmissibility. And then finally, the discretionary factors. And so as we look at that SIV, requirements, we can see that there are significant differences from asylum, and we'll dive deeper into those. So for SIV, I'm going to start with the challenges because I think those are the ones that need to be discussed a bit more with clients. There is a perception, which I'll discuss a bit more, that SIV is better than asylum every time. And I really do want to highlight a few ways that that's not always the case for some clients. SIV adjustment has some challenges that we'll discuss. And so the first one I want to talk about is the uncertain delays in processing times for I-485s. As some of you may know, IREP had this litigation in the past of Afghan and Iraqi allies versus Pompeo in 2018. And from that, we got a lot of information about some significant delays in SIV processing. Since then, many of us as practitioners have been operating in the gray, advising clients with, I'm not sure, I think it could be between this time and this time, because it has been very difficult to gain any certainty on USCIS's processing times for SIV adjustment of status. While many practitioners will claim they're sure of how long it will take, the reality is most of us don't actually know because USCIS doesn't publish those processing times the same way that it publishes asylum-based or any other type of base of AOS. And so I think that's the first challenge that I tried to highlight to my clients is I cannot promise you how long it's going to take. We get clients coming in saying, my brother got it in 6 months, but then we get clients that have been waiting 3 years plus. And so the uncertainty is one of the weaknesses, I would say, one of the challenges of SIV. Another major challenge, I'd say, is this admission requirement, which I highlighted. They need to be admitted as a non-immigrant. Again, if we're assuming that we're working with parolees, this is not an issue, but please do pay mind to this if you're working with any other Afghan groups, as we do see an increase in people from the southern border, clients from people from who've been admitted as refugees who want to adjust under SIV for whatever reasons. We need to keep this in mind. And I'll move on to the bars to adjustment of status because this is one of the key differences. There's not significant bars in most cases that do apply, but there are still quite a few bars that still apply to SIV applicants, bars to admissibility, or bars to adjustment of status. Some of those key ones I'd say are probably the deportable due to involvement in terrorist activity. And, you know, we have these material support needs. We're going to talk a lot about that later, so I won't get into that. We'll talk about those bars to admissibility. But in short, in case anyone is taking notes, a few of those bars that still apply are 245C, subsection 1, 3, 4, 5, 6, and 7. And so you do want to pay mind to that there are still some bars to admissibility that you want to pay mind to. And moving on to inadmissibility issues, the other challenge that we see with SIV is that they're only exempt really from the public charge rule and the labor certification and qualification for certain immigrants. So that's INA 212A4 and INA 212A5 that they're exempt from. This means that all other inadmissibility rules apply, or inadmissibility grounds apply. And the key difference here, the reason why this is important to consider, is that in the case of refugees and asylees, you have the option for the I-602 waiver. Whereas in this case with SIV, you've got to consider that you may not have that ease of access. I know myself and many other practitioners feel that the I-602 waiver in my experience, has been easier to get granted than an I-601 waiver. And so it's something to consider that that can be another challenge if there is an inadmissibility ground that you know of. And we can move to the key benefits. So of course, with every negative, there is also some positives. And I think the key positive that I'll start with is that currently the application for SIV adjustment of status is fee exempt. And that's been extended to the 30th of September of this year. With that being said, we're not sure if it's going to be extended again. And so that's something to keep in mind. Clients don't want to pay the fee, and there's such a benefit in not having to pay the fee. And so while that is present, that is one of the key benefits. Unlike asylum, there is no restriction on travel back to the home country. And I think this is one of my clients' biggest reasons why they prefer SIV time and time again. So this is one of the issues that I think comes up a lot in these cases, that they're eligible for both. And then there's no issue using the Afghan passport as well, because that's not the subject of their claim, and they're not at risk for losing any underlying status based on that. The other big thing I would say is the client perceptions. And I really do want to touch heavily on this, because I think this is the biggest factor that leads to why some of our clients make the decision. Overwhelmingly, I hear from clients that in the Afghan community, there is a positive connotation placed with SIV and a negative connotation placed with asylum or refugee status. And so this is something to take into account as we advise our clients, and sometimes maybe wouldn't understand why they want to go through the risk of more inadmissibility issues. The client perceptions, the community perceptions are very important to consider as well. I would say sometimes there is a faster processing time. I put 2 asterisks next to that because, of course, as I mentioned, these are very uncertain, but it's a gamble, right? It's some clients will put, will say they've come in 6 months, and some clients will say 3 years. But for many clients, they feel that this is a better bet to take, is to get the chance of a faster processing time. The final thing that I would say is that the eligibility for P3 is still a possibility for SIV. I'm not sure if many agencies, I'd be curious to know if any other agencies are referring clients for P3 other than just I-730 options for family reunification. But in our agency, we get a lot of requests for P3, and SIV clients are eligible, which just to give a little bit about P3 is a family reunification option available to Afghans, and particularly Afghans that are outside of Afghanistan. So family members, this can be a really great option for some clients, and they are still eligible for P3. So I'd say this is another strength. We can move on to, I think asylum is one that many of us have been working with nonstop from 2021. So I won't beat you guys over the head with this. We all pretty much know, I won't make the assumption, but I think many of us know the requirements for asylum, that asylees need to have their asylum application approved and have been in the United States for 1 year. This is where it gets tricky. We have this 1 year rule, which practitioners ourselves, we fall on different sides of what we decide to do with the 1 year requirement. We do know that there is a new interpretation that came out of the ability to apply before 1 year comes up, but that nothing can be adjudicated until 1 year has passed. So their adjustment of status can't be adjudicated until 1 year passed. I've seen most practitioners just telling clients that they're not going to apply until 1 year has passed, while other agencies have applied. But in any case, these are the requirements that we're seeing. And one reason, again, why some clients may be eager to go with SIV, because they don't want to wait that 1 year to apply for adjustment. And then again, the eligibility, I'll move pretty quickly through those. The main ones that I'll highlight are the 1-year rule, as I just mentioned, of being physically present at the time that you file, and being that being more than 1 year before it's adjudicated. I hope I'm not confusing these two. So we've got the physically present requirement, and then we've got this 1-year rule, which is a year before it's going to be adjudicated of being present in the United States. And then the other really big requirements that I'd say, and I'm going to really highlight on these, are the need to maintain asylee status to apply. So you need to continue meeting the definition of a refugee to be eligible to apply for asylum. So that's one requirement that we'll dive deeper into. And then we've got some sub issues there from resettlement and some other things that we'll talk about. And then finally, the admissibility issues that apply. As you'll note, there is no bar issues that we're talking about. We're really talking about just the admissibility issues. And I'll dive deeper on this next slide. Okay, so as I talked about the key challenges, some of these requirements, as I mentioned, are going to be the key challenges. So one that I'll start with is this issue of maintaining asylum status. I think this is one of the biggest reasons when we talk about travel and we talk about issues of where clients are going in specific, where clients are planning to travel. This is one of the challenges that I think most clients express to me about why asylum status may not be their preferred choice. Travel to the home country, as we know, is not recommended, is not allowed for the need to maintain this continued refugee status. So we want our clients to not be subject to any termination proceedings in the future or any issues with losing or failure to maintain asylum status because they've returned to their home country and or availed themselves of their home country's protection by using their home country's passport when traveling. And as we know, we can tell clients many times to get a refugee travel document, but sometimes the travel is urgent and clients have their needs. And so we have this risk that we're always playing with or working with rather in the asylum world that we're not working with SIV. So that's something to take into account and clearly mention to our clients that this is one challenge of asylum status. We also have the issue of firm resettlement, as I touched on before, as I mentioned, which is clients staying for prolonged periods in other countries that we need to continue to keep in mind that clients can travel for sure with a refugee travel document, but they need to keep this in mind while their I-45 is pending, before they apply for their I-45, all of those things in mind. And then I'll move on to the application fee since we talked about the fee exemption, which exists right now with SIV. It's important to take into account that asylum status or asylee AOS applications do not give a fee exemption. We have a fee waiver opportunity, but not a fee exemption. So for an asylum application, for some clients, they're paying $1,225 for their application, whereas some clients may be able to be granted a fee waiver or be considered for a fee waiver, but we need to inform our clients about this. I think this is another reason why many of my clients will opt for SIV unless they know that they're eligible for a fee waiver, which we do see most of our parolee clients being more able to provide the documentation needed for a fee waiver. I would say this is probably the biggest factor, honestly, as we think about the limited means that clients are coming to the United States with often. So this is an important factor to highlight to your clients, this application fee. I'd say that the next big one is the 1-year rule. I talked about it a lot before that we've got this new interpretation, but some clients are discouraged by the fact that they could apply for SIV right away once they have their COM approval, SIV adjustment of status, to be clear, versus having to wait in some practices. Again, this is practice by practice. Some agencies and attorneys are filing right away, so it really does depend on what your agency or your firm is practicing, but this is something to take into consideration based on your practice. And then finally, we talked about client perceptions. And again, I just want to touch on that again, that in the broader community, there is this perception that asylum status is like a lower status. And so it's important to consider that that might be one of the downfalls that may make them not want to consider asylum status. But let's jump into the key benefits because I think this is under discussed. There are some very key benefits about asylum, and there is a reason why many practitioners are still pushing their clients towards asylum adjustment of status, asylee adjustment of status. One of the biggest reasons is that there are no bars to adjustment of status for asylees. So there are no bars that they're going to have to be thinking about. Am I subject to this one, or the other? And as I've listed several of the bars before that apply to SIV, some clients who have different circumstances may benefit from, I think many clients would benefit from the ability to not have to worry about any of those bars. The next issue I'd say is the inadmissibility issues being easier to waive generally with asylum. And I touched on that before about this ability to use this I-602 waiver and having that many of us have a good relationship with the I-602 waiver where we might feel more confident about that than moving to an I-601 waiver. So that's something to take into account as well. Next, I'd say the posted processing times, I feel gives a lot of clarity to clients, the ability to look online. There's always a caveat to that, right? We know that those posted processing times don't always reflect the reality. But for many clients, just having a place where they can check to go see how long about their case may take provides an ease that's hard to quantify. You know, as attorneys, we want to like have a hard fact why it's better, but sometimes that ease actually does impact the clients and make it easier for them to work with an asylee AOS. And then finally, the asylee benefits are enormous in states like California and other states that many of us are practicing in, even after the point of adjusting status. And so the ability to maintain those benefits, it is really case by case. It depends on the state you're working with and where they find the cutoff and whether they'd still find a client eligible for the asylee benefits if they adjust based on SIV. So it's important to take that into account as well and let our clients know there are scholarship opportunities and grant opportunities and all types of things that require you to be listed as an asylee. And so that's something to consider as we advise clients as well on asylee AOS. Okay, we can move on. So finally, I just to circle back about some of these considerations, to add some additional considerations on top of these, I think it's important to consider timing, status, fees, and perceptions. So timing is this 1-year rule versus the immediate filing. We talked about that, but I think the other timing to take into account is when your client comes to you. At what point in their SIV process has they come? How long have they waited? What kind of state are we working with? Are we impatient and right at the edge of I've been waiting so many years, or are we at the new stage of I've got a lot of time to spend and I'm ready to wait? Next, I'd say the fees, as we talked about, the financial considerations are incredibly important to take into account. Next, the status of asylum being approved and how that can impact how clients may see the urgency with asylum being an indefinite status, something that they can carry long-term versus the feelings or the sentiments that might come around a COM approval alone. Again, these are sort of intangible things, but things that we see coming up with our clients. Of some clients feel insecure if they only have COM approval, whereas a client with asylum approved may feel more secure to wait longer term. So things to consider and discuss with your client. And then finally, these community perceptions, which I wanted to hit again and again and again throughout my presentation, because I think we underestimate how important client and community perceptions are into the decisions that our clients make. So it's something important to talk with your clients and while we provide reason, also to take into consideration rather the perceptions that they might have about these two statuses. Ultimately, at the end of the day, the client is going to be the one that's often left to decide which they prefer, but I think it's really important to highlight these factors to clients and give them the clearest picture that we can in what these two options would be if they were to adjust status based on these two different statuses. And so before we move on to the next amazing presenters, I did have a question for you guys as practitioners, as people working in this field. When are you all deciding when to file your clients' asylee AOS applications? Like, are you deciding the 1 year? Are you waiting? I see people saying 6 to 8 month marks. Are we doing right away? Are there any practitioners who are applying as soon as they get approved? I know we all have different workloads and all those things. So I'm seeing kind of an average of like 6, 8, 9 months. It seems like it's a little bit between, you know, half a year and a year that majority of the people in the comments are saying. So it's really interesting to hear that. Yeah, I'm still seeing a lot of 6 to 8 months, 9 months. Yeah, some are undecided. I think that's a really good thing to take into account. My previous agency, it took us a long time to decide what are we going to do. We were in the face of an emergency, so it's good to see that people are having all different takes on when to apply. Well, thank you all for your time and for hearing me out on this really complicated issue that we're all facing, that many of us are facing. So thank you all.
Thank you, Sarah. That was so informative. I wonder if I could just ask you a question or two that came in the Q&A box. There were
Of
a couple
course.
questions about interviews. I don't know, kind of specifically about SIV interviews. One,
Yeah.
are you seeing them in all cases? And two, what are they like? Are they as intense as an asylum interview? I don't know if you could speak to that.
That's such a perfect issue. I just had an interview on Monday, an SIV AOS interview. That is another very key consideration. Thank you for bringing that up in the chat. I think interviews for SIV, in my experience, have been generally less intense. But I will add the caveat that, as we know, there are these 0-unit cases. There are 0-unit cases. There are very edge of, how would I explain it? People who worked on the edge of the operation, right? Don't have much information versus people who were 0-unit operatives or had these really intense and complex roles. So I would say take into account that how complex your client's case is. The case that I just represented was transportation worker. And so we were working with very simple questions, very simple, clear. It was a very quick interview. I think if we didn't have document issues, we would have been out of there in and out in 45 minutes at most. Whereas asylum, you know, you've got all these bar questions, the bars to asylum. And there's a lot, I think, on the front end that you have to do. That being said, with SIV, you do all of that with COM. So I think it's really important to just weigh, you know, you might do more in the beginning or more in the end. And I think that's the key difference.
Great, thank you. That's really helpful.
Yeah.
Well, speaking of the bars to asylum, I think that's a good segue into our next topic, which is TRIG and AOS. So the terrorism-related admissibility grounds and adjustment of status. So what's important to keep in mind here is when we're at this stage of applying for adjustment of status for our clients, what we want to be looking at are those grounds of inadmissibility. So that is what applies when a person is seeking adjustment of status. So most of the asylum bars that we're concerned about at the asylum stage, you know, the persecutor bar, firm resettlement bar, you know, criminal bars, don't apply when we're seeking at the adjustment of status stage. So that's not the framework that we're looking at. Rather, we're looking at whether the person is admissible to the United States. But I would say the one kind of big exception to that are the TRIG bars. So the TRIG bars are applied both at the asylum stage and when the individual is seeking adjustment of status. And that is because the TRIG ground is a ground of inadmissibility under 212A3 and is also separately incorporated as a bar to asylum. So we need to think about it at both stages. Okay, so this is such a big topic, the TRIG bars, and I'm going to assume a little bit of underlying familiarity with these issues, such that I'm going to go through this relatively quickly in terms of the exemptions that are applicable to Afghans, and you will have these slides that you can access if you need to refer to them. But basically, these TRIG grounds are found, as I said, at 212A3B of the Immigration and Nationality Act. and they will bar individuals from certain types of immigration relief, including asylum or adjustment of status, if the person has engaged in or incited terrorist activity, there's reason to believe that the person has engaged in terrorist activity, or if they are a member of a Tier 1, Tier 2, or Tier 3 organization, or if they have received military type training on behalf of a terrorist organization. And the organization, that is most commonly sort of implicated with Afghan cases is Taliban, which is considered to be a Tier 1 terrorist organization. And so the definition of engaging in terrorist activity includes providing material support to a terrorist organization. And so that is the sort of prong of the statute that is quite broad, actually, and is most applicable to our clients. This is the sort of part of the statute that we are usually most concerned about, and that is whether or not the individual has provided material support to a terrorist organization. And again, it's been interpreted so broadly that it can end up sweeping in a lot of people whose conduct is not, would not meet what we think of as the everyday definition of engaging in terrorist activity. And the reason that I say that this ground is so broad is the way that it's been interpreted by the Board of Immigration Appeals and by the federal courts. So there's an important case from the Board of Immigration Appeals called Matter of ACM. This was issued in 2018. And before this case was issued, many advocates would try to make arguments, for example, that if the individual had provided material support under duress, that inadmissibility ground did not apply to them. There were also arguments about whether a very small amount of support to that organization, de minimis support, would be considered an exception, so that the ground of inadmissibility simply did not apply to that individual. And the board rejected basically all of those arguments in Matter of ACM. This case was about a Salvadoran woman who was forced to cook and clean for guerrillas under threat of death. So this was a case that involved duress. And the board found her ineligible for asylum because her actions constituted material support to a terrorist organization, even though the actions were involuntary. So this is just to point out to you sort of how broadly the statute has been applied, has been interpreted, and to know sort of that making an argument about an exception is very difficult. Where you can have luck, and this is why we're lucky that we have these exemptions under the statute. So I just want to draw a distinction between an exception, which is very hard to argue, and an exemption, which is where you're going to find the most relief for your clients. So a situational exemption is something that is created or promulgated by the DHS Secretary and the Attorney General in consultation with each other, and they have the authority to make available exemptions to the TRIG grounds of inadmissibility. So the secretaries have exercised this authority on several occasions, two of which have been specific to Afghans, and several of which are not specific to Afghans, but can certainly aid Afghans in their applications. And you will see the situational exemptions listed on this slide here. I would say the most common situational exemption that you will see is duress, right? So this exemption has been around for a long time. It is not specific to Afghans, but it applies in a situation where there was no way out of providing support to the terrorist organization. So sort of the classic, someone put a gun to my head and forced me to give them money. That support was provided under a duress, and it is possible to get a situational exemption in that situation. And in terms of statistics, the vast majority of TRIG exemptions have been granted because of duress. So in last year in 2023, there were 1,254 exemptions total granted, with the vast majority being duress-related exemptions, and that's 982. So that's the one that you're likely to see, I would say, most often. And again, this has been around for a while. It's not anything new. In terms of the more recently designated exemptions, there was in June 2022 new exemptions for limited material or insignificant material support. And these are not specific to Afghans, but they have the potential to aid Afghans in particular. And in the Federal Register notice that talks about these exemptions, they give examples that are specific to Afghans. So for example, paying the Taliban for utilities, serving the Taliban at a place of business where refusal would jeopardize likelihood, paying a fee to obtain a passport, things like that. So it's not for people who sort of share the ideology or beliefs of the Taliban, but where the material support is insignificant or pursuant to what they call this routine sort of commercial or social transaction. So that, again, is a significant change. And then we have 2 exemptions created in June 2022 that are specific to Afghans. So Afghan civil servants who have been serving under the Taliban, and then Afghan allies. So if there are individuals who worked against the Afghan Taliban or against organizations that engaged in activities that targeted the United States, they may be eligible for exemptions as well. Okay, so again, kind of flying through those exemptions, you can refer back to them in terms of the specifics. But what I really wanted to talk about more is the process and how these exemptions are considered when you have a client, for example, who's already applied for asylum, or if you have a client who's applying, for SIV and hasn't gone through that process already of getting an exemption. What is really tricky about the exemption sort of process, I would say, is how kind of mysterious and non-transparent it is. So there is no specific application that your client fills out saying, I want an exemption. You don't get an approval notice saying, an exemption has been granted under this ground and you're exempt from 212A3. It's much, much less transparent than that. So USCIS will decide when they're adjudicating a benefits application, whether the person qualifies for an exemption. One of the things that they look at is that the applicant has fully disclosed in all their applications and interviews, basically any contact that they've had with a terrorist organization, as well as the circumstances behind the material support that was provided. And at that point, DHS will decide whether or not to grant an exemption to that individual. As I mentioned earlier, exemptions cannot be granted by the immigration judge. They can only come from DHS. And again, where I think this gets complicated when we're talking about adjustment of status is if you're taking on a client at the adjustment of status stage, maybe you did not represent them in their asylum application. Maybe they were pro se before the asylum office, and you really don't know whether or not all this information, if there is a possible TRIG issue, was all this information properly disclosed before the asylum office? Can you be confident that there's not going to be an issue at the adjustment stage? So I would say in terms of best practices for adjustment of status applications, one is really to take special care with pro se asylum applicants or those who had different representation before the asylum office. If your office represented them at the asylum stage, you might feel, pretty confident. You went to the interview with them. You're confident that this information was disclosed before the asylum office. Then that's a little bit of a different scenario. But if you really don't know what was discussed before the asylum office, I really think it's worth it to get that information. I would suggest doing a FOIA and specifically requesting the A file, including asylum officer notes and assessment. And that might give you a sense. At the very least, the notes will have that Q&A transcript of what's been discussed between the asylum officer and your client. So you'll at least know that this information has previously been raised and discussed before the asylum office, that it's not coming out for the first time at the adjustment of status stage. And then possibly in their assessment, there might be some discussion of the TRIG issue and the exemption, but that's not entirely clear to me, sort of how much information they'd be willing to release at that stage. This is something that they're usually pretty guarded about. And that's something I sort of wanted to pose to the chat. Has anyone done a FOIA for their client's asylum application or asylum file and been able to get any information about TRIG issues or how they were adjudicated before the asylum office? Someone said no, so maybe that's the answer. Okay, all redacted, yeah. Okay, yeah. That's interesting. I don't know, Sarah, if you've had any experience with that yet.
No positive experience.
Okay.
So, yeah,
Okay,
I'm
good.
seeing,
Well, not good, but yeah.
yeah, I'm
See
agreeing
someone
with those in
saying
the
they
chat.
got FOIAs. Okay, but the notes were not that helpful. Okay, yeah. So I still think it's worth it to do. Or if, for example, you could get the file if you know the person was represented by different counsel, perhaps getting that, counsel's notes or something of that nature. But this is something that I would say you want to dig into a little bit at this stage and disclose as appropriate, right? So when we're looking at the 485, questions 48 through 50 are really the ones that are designed to get at the TRIG issues. So if you know that issue has been addressed at the asylum stage, this is certainly something that you would, perhaps check yes to, but then explain how this is something that was brought out at the time that the client was granted asylum. But it is a bit of a tricky situation that, again, the exemption process and the TRIG process in general is sort of not very transparent. So it makes it hard to know whether clients have actually been granted exemptions or not. And I would just sort of close with a little bit of the disheartening thought that most courts have found that inadmissibility and asylum determinations are distinct. So just because the asylum has previously been granted does not mean that the government cannot raise TRIG issues at the adjustment stage. So courts have basically said they can raise these issues again at the adjustment stage. I will say in the 3 cases that you see here, none of these cases deal with a situation where an exemption was granted to that individual. These are actually all cases where the individual was granted asylum by the immigration judge, and the TRIG issues really didn't come out at the asylum stage. I think this is more common to see in immigration court where they might be sort of glossed over. The judge is not as familiar with TRIG issues. And for whatever reason, the issue is really never brought out and never litigated. And then it becomes a problem at the adjustment stage. And again, these courts have said, yes, the government can look at this issue again and can raise this as an admissibility ground when you're applying for adjustment. But I will say, I think our hope and expectation would be that if you do have someone that has previously disclosed, they got an exemption that was, explicitly granted at the asylum stage, it should carry over to the adjustment stage. You would have a good argument in that regard that it would be arbitrary for the government to grant it at the asylum stage and then to not grant it at the adjustment stage. I would be much more concerned about a situation where the issue was not fully litigated or fully raised. And then the individual did not get an exemption, and this comes out at the adjustment stage. So I think, again, especially if you're dealing with a situation where a person is granted asylum by the immigration judge, just screen extra carefully for these issues, because you can bet DHS is going to be looking at it with a fine-tooth comb again at the adjustment stage. The one positive case law on this, surprisingly, we don't hear this very often, is from the Fifth Circuit. And they actually found that they found the opposite to the other courts, basically. So in that case, they found that collateral estoppel applied when the identical issue was previously adjudicated. So in that case, the individual had been granted asylum before the immigration court. At the adjustment stage, DHS raised the TRIG issue. They found the individual inadmissible. And in that case, the Fifth Circuit sided with the non-citizen in holding that this issue has already been litigated and you cannot sort of redetermine that issue. But again, that is sort of the minority view in terms of these issues. Most courts are finding this is an issue that can be raised and can be litigated again at the adjustment stage. So just important to keep that in mind. All right, and with that, I'll turn it over to Rebecca.
Thank you, Liz. So I'm going to talk about polygamy and derivative status. I have a little poll later on for you to put in the chat who all has experienced any of these issues that come up. If you can just go to the next slide here. So what is polygamy? Just click one more. I had tried to make it more fun. So let's look at what different agencies, how they define polygamy, just polygamy by itself. The USCIS policy manual defines it as a custom of having more than one spouse at the same time. The website for Afghan parolees that I'm sure many of us look at all the time, just click one more time, I have them appearing sequentially. Perfect. There's a similar definition at this Afghan parolee website, meaning polygamy is a religious practice or historical custom of having more than one spouse at the same time, so very similar to the policy manual. And then the last I looked at the Department of State's Foreign Affairs Manual, or the FAM, describes polygamy as the historical custom or religious practice of having more than one wife or husband at the same time. The FAM also refers to polygamy as a plural marriage. And as we know, and as we do work with it's not just Afghans, this happens all around the world. It is a historical custom and practice, and it's not legal. Polygamy is not legal under the laws of the United States. So after reviewing just the term polygamy by itself and different definitions by different agencies, let's talk about under immigration law. What does practicing polygamy mean? So under INA 212A10A, that's the inadmissibility ground for polygamy, an immigrant who is coming to the United States to practice polygamy is inadmissible. And you can look to the actual form I-45 for adjustment of status, page 15, number 80. And that is the question. Do you plan or intend, so it's prospective, forward-looking that we'll talk about, to practice polygamy in the United States? And I know it's kind of wordy here on this slide when I cite to the FAM, but I do think it's really important for us to read over the FAM's definition of polygamy, even though this presentation today is for adjustment of status and the FAM is only persuasive. It doesn't mean USCIS is not binding, doesn't have to follow it, but it is interesting to learn what consular officers are looking for. So for this forward-looking interpretation, the FAM actually provides examples of what practicing polygamy is. It emphasizes the fact that even if a person may have practiced polygamy in the past, had more than one spouse at the same time, that doesn't necessarily make it sufficient to find them inadmissible in and of itself, the practice of past polygamy. Rather, the consular officer is supposed to find that the applicant will evidence that the applicant will maintain this married relationship with more than one spouse once they're moving and living in the United States. So essentially, it suggests that if the consular officer believes the applicant will continue their relationship with, let's say, the left behind spouse in the country of origin or maybe some third country, visiting the spouse, providing financial support, and this comes up, I know, when children in common are involved, which we'll talk about a little bit, sending money to the child, but goes usually to that spouse, second spouse as well. Keeping in phone contact with the left behind spouse, these could all be considered as evidence that they're continuing to practice polygamy once they've moved to the United States. It is interesting because at least under the FAM, it seems that even if they legally, under their laws, remain married to that second or third spouse, but have no active relationship with them, they should not be deemed as practicing polygamy for purposes of INA 212A10A for adjustment of status. But it can be a pretty stringent definition as well, especially, like I said, when children are involved and they're sending money or they're doing these days FaceTime or WhatsApp video with that child, where they oftentimes, if it's a young child, they have to also talk to the adult or the second spouse. But just keep in mind, the FAM's not binding on USCIS, but I do think it's very important for us to review to get some examples and insight. So let's go to the next slide here. So I think those definitions are pretty in contrast to a more recent, I think this decision was published by the Third Circuit in August of last year. The Third Circuit took a pretty broad view of what practicing polygamy means, but in the context of Mr. Al-Hassani's application for naturalization and in reviewing the good moral character, the 5-year statutory period, which, as many of you know who do naturalization, you can look beyond that 5 years. So in this particular case, in summary of what the Third Circuit found, they applied a broad interpretation of practicing polygamy and found that Mr. Al-Hassani, who was a lawful permanent resident, he was married simultaneously to 2 women within 5 years before filing his naturalization, his N400 application. And the simple fact that he was simultaneously married to more than one person at one time is the definition of practicing polygamy for the Third Circuit in this context under 212A 10A. Thus precluded him from having his naturalization application approved. So in this case, I'm going to give you just some of the facts because it'll help us work through some other slides that we're about to talk about. Mr. Al-Hassani was a native of Syria. He married his first wife. They had a child in common. He didn't divorce her, and he married his second wife. He then was able to leave Syria, and he came to the U.S. with his first wife and their child. Eventually, Mr. Al-Hassani ended up alone. His first wife and child moved to Morocco, and his second wife was still in Syria. And miraculously, he was able to adjust status. I'm not sure what happened at the adjustment stage. That's not in the Third Circuit opinion, but he adjusted status. And when he applied for citizenship, he had never divorced either of his wives. He did say, and we'll talk about this later, but it's good to have in mind, he wanted to try to divorce his wives, but he was worried about the social stigma that could cause them, or maybe even put them in danger in their home countries if they got divorced. And Mr. Al-Hassani, not sure if he talked to a family lawyer, but he lived in New Jersey, didn't realize at the time, I assume, he couldn't divorce that first wife who was in Morocco because they had married in Syria. Later, we find out, and we'll discuss, under New Jersey law, even if they got married in a different country, they could still get a divorce because Mr. Al-Hassani lived in New Jersey. The second wife, of course, he couldn't divorce because under New Jersey state law, under our federal laws, we don't recognize that second marriage. So he really needed to divorce his first wife. So eventually, he did divorce his first wife under New Jersey state law, and I assume, hopefully, he will become a U.S. citizen if he hasn't already. So I just put this as a comparison with a lot of background information so you understand that this is the Third Circuit's view. That's not binding on USCIS. Liz and I actually have a great practice pointer that's on the resource page that Corey will review at the end that you can check out to really delve into more of these issues with what practicing polygamy means. But we advocate for obviously not such a broad reading of practicing polygamy, simply being married to 2 spouses at once, but clearly a more narrow reading, because we really think about our clients who are in a polygamous marriage, have children involved, and it can be really harsh on them. So let's go to the next slide here. So the big question, how does polygamy impact applications for adjustment of status? So Sarah did talk about earlier a little bit about inadmissibility and the differences for the waivers between asylee adjustment of status and SIV adjustment of status, and some of the pros and cons. So maybe with polygamy now on your mind in the inadmissibility ground, we can consider, what might be better for your client if they're eligible for both SIV. And this is thinking, before they even get to adjustment, maybe when they're coming here and you're deciding on SIV or apply for asylum, is something to have in mind. So under our laws, asylum applicants, as we know, are not subject to the grounds of inadmissibility. There are, of course, certain bars to asylum that Liz just discussed some of the TRIG bars with you earlier. Asylum adjustments, they are subject to most grounds of inadmissibility, as Sarah said, but there is a very generous waiver which includes the practice of polygamy. So you can waive INA 212A, A10. And that waiver is found at INA 209C, and it's on Form I-602 with USCIS. And for that waiver, you just need to show, the applicant just needs to establish that the waiver serves in humanitarian purpose, preserves family unity, or is otherwise in the public interest. So it's pretty common and normal to submit the I-602 application along with the adjustment application. But I do want to have in mind, kind of similar to what Liz was just talking about with collateral estoppel, if the asylee adjusts and files that waiver and it's approved, think about Al-Hassani's case in the Third Circuit in establishing the good moral character at least 5 years prior to naturalization. So that adjusted asylee still might want to consider a divorce, which we'll talk about in a little bit, ways they can divorce so that they can be eligible for naturalization. So I'm kind of interested if anyone has any experience with that. Put it in the chat, please. We'd all like to know. Of course, if you click a little bit more, SIV, adjustment of status, is it's employment-based. So for both practitioners representing employment-based applications, because that is SIV, or even family-based applications who are applying to adjust status, there's no waiver available for the inadmissibility ground for practicing polygamy at 212A10A. So I head our mentorship project here with Clinic, and we've had a number of cases, SIV adjustment cases, where the client is still simultaneously married to one person. So I've seen these cases a couple times. So I'd love to know, even from you all, it's okay to chat now, even though I have it later, to let us know if this has come up. But it seems to come up more in the SIV context, because there is no generous waiver like there is for asylees. So with these cases, you really want to delve into, one, make sure that those marriages both are actually valid. You want to check out the State Department website for Afghanistan, their reciprocity of documents, and make sure when you get a copy of that marriage certificate, it is a valid marriage on both, whether the first or the second, or if there's a third marriage, make sure they're all actually valid, that marriage is in Afghanistan. And then you want to ask your client probably very private, personal questions, but you have to ask them, what is the nature of their relationship with the other spouse or the other spouses? Do they send them money? Are there kids involved? Do they talk often? Do they have plans to bring them here? Are they thinking of maybe submitting a request for humanitarian parole for that other spouse, which I know in the Afghan context, many of the other spouses are still stuck in Afghanistan in very precarious situations. So it can be a really difficult conversation, but you really got to delve into that as you prepare their application and then prepare them for their interview. And I did put a great link. Shout out to IRAP. They have a great resource called Overview of Marriage for Immigration Purposes and Practice Guide. I think you have to actually request access to it to download it. So you can check out that link. If it doesn't work, we can put the link in the chat. But it's a great resource to really understand marriages and the different requirements in Afghanistan as well. And another note, marriage in general is valid in the place where the marriage is performed. So that's the place of celebration rule. So as I mentioned before, for the most part, that marriage, of course, we don't recognize the second marriage, but the first marriage, if it was legally valid, we will recognize. And one thing on Afghanistan, a lot of time marriages actually aren't recorded, except when the applicant needs it, such as for immigration purposes. And also that's on the State Department website, which you probably run into outside of major cities. A married woman might not be permitted to register her own marriage and may also have scant knowledge of the individuals who served as witnesses to the court process. A lot of us are representing males, whether it's FAB or Afghan. A lot of the parolees came and then brought their wives or children later. But also if you are representing a female dealing with this, just know it can be more difficult for females in Afghanistan to register their marriage. They might have less access also to getting a copy of it. You can go to the next page here. So we get a lot of questions here at Clinic about derivative benefits, especially, well, both the asylee and SIV context. Who is eligible, both as a spouse, which is pretty clear, or a child, which is a little more fuzzy for all of us. So as I just kind of explained, the legal validity of a marriage is determined by the law of the place where the marriage was celebrated, unless there is a strong public policy against it. So here in the US, there is a strong public policy against polygamy. It's outlawed here. So we will recognize, USCIS, our immigration laws, will recognize that first marriage as long as the applicant can show it's a valid legal marriage, usually a copy of the marriage certificate. The second subsequent marriage, unless the first marriage was terminated, we will not recognize. Thus, that subsequent spouse, if the first spouse, the marriage to the first spouse is not terminated, cannot obtain any derivative benefits as a spouse from any petition filed by the principal. So that's pretty clear. You'd have to consider as her representative or of the husband, or either way, you'd have to consider if that person's eligible for another form of relief, such as an asylee. Maybe she goes to a third country, can get refugee status, family-based petition through some other means, maybe not, or if she can come paroled in, but again, you wouldn't want that principal most likely to request parole for that subsequent spouse, but that can be difficult. So the more complicated question, if you go on to the next page here, is which children can qualify for derivative benefits? We just got a question yesterday on our hotline about this. So let's look at the first column. I have biological children, and the second column I have non-biological children to make it hopefully a little more easier for you to understand. So in general, a principal applicant's biological child, whether born to the first or subsequent wife or in wedlock or not, can derive beneficiary status if that biological child qualifies as a child under INA 101B1. And I myself oftentimes look at the statute, look at the law, and review it to remind myself of what the rules are. We'll talk about the Child Status Protection Act in just a little bit. So let's put that aside for now. So the first category there in wedlock first marriage. So if the child is born in wedlock, that means the parents were married and then the child was born, is considered legitimate. These are very archaic terms for many of us these days. That parent-child relationship is enough, and just produce the child's birth certificate, hopefully list both parents on it, right? For children born out of wedlock, meaning the child was born to two individuals who were not married at the time of birth. That's under INA 101B1A. If the child was born out of wedlock and it's with the mother who has left, because the natural father has abandoned, it's with the father, if the father has left, there's no further steps. So it's much easier for a mom who has a child out of wedlock to demonstrate that relationship with the child. A birth certificate is enough listing the mom. Although it's a little more difficult if a child's born out of wedlock and it's the father who's trying to now petition for the child. That father must take an additional step and show that they have a bona fide parent-child relationship that exists between the father and the child. I've done a number of these cases. I'm sure a lot of you have too. It often comes down to, at least in my experience, no matter how much evidence I submit of financial support, emotional support, general welfare support, it comes down to a paternity test. So I'm sure that happens to a lot of you too. And a brief note, I'll try to be brief because I don't want to get into the weeds of the Child Status Protection Act. I will say Liz here and our good colleague Charles Wheeler They have a couple good resources on the Child Status Protection Act. I put links to that in the resources. But in general, so we all can be on the same page with the basics, for derivative asylees, under the Child Status Protection Act, the CSPA, that age is frozen on the date that the principal asylee's parent files the form I-589 and hopefully has listed the child as a derivative. So as a result, any unmarried child who is under 21 on the day the principal asylee submits the asylum application should remain eligible to be classified as a child, as long, like I said, as long as the parent put the child to be included on the asylum application. And that's true up until adjustment. There is a caveat: a child who's married, either at the time of filing or at the time of adjudication of the adjustment application, is no longer considered a child of the principal and no longer eligible to adjust status. So I'm always telling my derivative children who are my clients, don't get married, be careful, at least understand the law if you do. But, and this has happened in a case that I had, a child who was married after the grant of derivative asylum status, but since divorce prior to the adjustment, may qualify as a derivative child. I don't see that happen often, but it has, especially if you tell them, well, if you get divorced, you can still be eligible. That's an option. And for derivative SIVs, again, to not get into the weeds of this too much, Liz and Charles have a practice advisory. It's just like a page or two long, so it's pretty succinct for you to read on SIVs and derivative status. I would check it out. But the basic rule: if the child was unmarried under the age of 21, at the time the principal SIV parent filed the Form I-360, that child may still qualify for adjustment under the Child Status Protection Act. And to determine the adjusted age, which can often bring a lot of confusion, even for myself, it's calculated by subtracting the time that I-360 is pending from the child's biological age. And just remember that, check out the visa bulletin. The preference category for SIV derivative children in this situation is the EB4, that employment-based category. And the USCIS has some new policy guidance, which Charles has written extensively about, that updates when an immigrant visa becomes available for the purpose of calculating the applicant's age under the Child Status Protection Act. Again, I'm not going to delve into that too much, but just check out the resources and do know that USCIS new policy for calculating this date is quite different still from the Department of State's. Now there's two categories. There's category Chart A, the final action date, and Chart B, dates for filing the visa application. So just know there is a difference, and just make sure you're calculating the age correctly, whether it's consular processing, which can be a little different in the calculation, or for the purposes of our presentation, adjustment of status with USCIS. And then lastly, on the Child Status Protection Act, there's another step that the child must take to benefit from this adjusted calculation of their age. They must actually seek legal permanent resident status within 1 year. So for most children, that could mean filing for an immigrant visa, or purposes today, adjustment of status, such as filing the Form I-485 or paying the immigrant fee to the Department of State. And just again, remember, the derivative must file their own separate I-485 application to be included in that. And then the non-biological children here in this second category, where we get the most questions probably is on adopted child. So under INA 101B1E, for an adopted child to be considered a child under our immigration law, that adoption must occur before the child turns 16 years of age and be coupled with 2 years of legal custody with the adopting parent, and also show that they've resided with the adopting parent for 2 years. There is a brief exception if that child has a sibling So as long as the second brother or sister who's adopted, they can also be under 18 at the time of adoption. So just check out that section of the law and make sure you clearly understand it. And one very, very important note, that 2-year custody and residency requirement, this is really important, may be satisfied before or after the legal custody or adoption. So that's really important for those who haven't, and when you're talking to them, haven't met it, that might need it later, after the adoption. And lastly, on the law, the natural parents of the adopted child cannot ever obtain benefits through the natural child once adopted. So it kind of reminds me of that SAJS provision that the parents can never derive any immigration status from that child through that application. So again, check out the Department of State reciprocity for Afghanistan. This is where we get a lot of questions because according to the State Department, under Islamic law, there is no legal adoption. Also, so you can't get an adoption decree. However, I will say a lot of Islamic experts argue differently, that there is a form of adoption. So just know if you have a case that might involve an adoption, they meet that 2-year requirement, do a little more research. If you're a clinic subscriber or affiliate, reach out to us. We might have some good research on this, or IRAP. Just make sure you fully review it. There is the option for formal guardianship in Afghanistan. I was going to read to you everything from the State Department webpage, but I suggest you look at it yourself. At least an option that I was even looking at that a lot of adoption agencies cite is making sure the child does obtain that formal guardianship in Afghanistan, and ensuring clearly that all the natural parents, all those ties have been severed, and then leave the country, because to exit the country, they should have to get that formal guardianship certificate, then adopt them legally, if that makes sense. Also, I want you to check out our I-730 manual. We have one that should be released soon. We talk about cultural and customary adoptions, so that's something too you might want to consider. And I do know a lot of wonderful advocates out there, maybe some of you are on this call, who are making really interesting arguments, because this whole adoption with Afghans trying to get their adopted children here is coming up quite often. So we'd love to learn from you if you have anything to share with us in the chat. And then lastly, the easiest part, stepchild. If the child to a subsequent spouse, if they're still married to the first spouse, so that second spouse, for instance, is not a valid marriage. So those children, even if they're married and under their law before age 18 for the child, cannot derive immigration benefits. They'd have to get divorced to the first spouse, make sure that legally marry the second spouse, all before the child turns 18 to be considered a stepchild. Or you could maybe potentially consider adoption. So we get that question a lot too. And then lastly, which I touched on a little bit on the next slide here, what are some options for divorce? There is customary divorce, and I listed a case here from the Fourth Circuit, Michael Adeji v. Alejandro Mayorkas, where in the state, well, the Fourth Circuit found that a customary divorce for a lady who, a legal permanent resident from Ghana, neither her nor her former spouse were living in Ghana, but they did still get a divorce in Ghana. Therefore, for the state of Virginia did recognize the divorce, even though neither party to divorce was living in Ghana. That's just one case to consider regarding customary divorce, but probably more easy, like Mr. Al-Hassani did in the Third Circuit. State courts may also divorce a couple that was married abroad, as long as one member of the couple is domiciled in the U.S. for a certain period of time. And if divorce is not an option, or if they don't want to get divorced, just let them know there's not going to be derivative benefits for that second or subsequent spouse. And consider if that second or subsequent spouse is eligible for some other form of relief to be in the United States. So let's go on to the next slide. This is the last slide, and I want to give my colleague here, Corey, enough time to talk. But this is just a case example about a hypothetical person named Abdullah. He is an SIV applying to adjust status. He has a wife in the US with 4 kids, and he also has a wife abroad, and they have children. So I kind of go through this hypo of how would you counsel Abdullah in applying for SIV adjustment of status. First, make sure that both of those marriages are valid. You should consider with Abdullah whether he has intentions of divorcing his second spouse. You should inquire into the nature and extent of his relationship with his second spouse. You should also remember the definition of practicing polygamy is for thinking. So if he no longer has an active relationship with her, he should still consider, because a lot of officers do ask, does he intend to divorce her, and how is he going to respond to that question before an officer? And lastly, the children he has with his second spouse, they're his biological kids. So just remember, he probably needs to show that additional bona fide relationship with them born out of wedlock, but he should still be able to petition for them. And then you can consider with him what else his second spouse might be eligible for. So the very last slide is just a call for you to add to the chat. Whether you have any of these issues, anything we talked about today regarding polygamy has come up, just put it in the chat for others to learn. And I'm going to let Corey take it away talking about travel.
Thank you, Rebecca. Okay, so we're going to briefly turn our focus to applying for advance parole and travel documents and kind of the types of travel documents for which a person with a pending adjustment of status application is eligible, and then the differences in applying for advance parole because you're an SIV adjustment applicant versus a refugee travel document as an asylee adjustment applicant. And then we're going to take a look at just briefly at the overview of the application process. So this is a non-exhaustive list of the various types of status from which someone can request advance parole by filing I-131. The type of document that they receive that permits their re-entry into the US. The name is different depending on the status from which you're applying in some cases. We're not going to go into detail of each of these statuses, but this is some that could pertain to our Afghan communities that we serve. But today we're just going to be looking at advance parole for those who are applying for adjustment of status based on the SIV process, and then refugee travel documents for our asylees and refugees. So first, we're going to take a look at advance parole if you're an asylee applying for adjustment of status. As we know, and as Sarah went over, they apply for adjustment of status based on INA 209. But even though they don't apply under INA 245A, they still do qualify to file Form I-131 with their I-485 or as the I-485 is pending to receive that refugee travel document. So if they're applying based on their asylee or refugee status for adjustment of status, they must apply for a refugee travel document which is like the advance parole for asylees and refugees before departing the US, and then do their biometrics here in the US. But unlike advance parole for regular SIV adjustment applicants, they can depart the US before the approval of the refugee travel document and receive it at a consulate overseas. So that's one key difference here. There is a way for asylees or refugees to apply for a refugee travel document while outside of the US within 1 year of departure. And this is a very special scenario that is not quite within the scope of our application of our presentation, but that is a option for some people. Generally, it's not recommended that asylees or refugees travel at all unless there's an urgent need to do so. And they should be advised that returning to the country of their claimed persecution or traveling with that passport from that country could result in their asylee status being terminated. And so it's advisable that they do not do so until they naturalize, although urgent situations do come up, and that's where the refugee travel document does come in, or an emergency advance parole document. So if asylees or refugees do not obtain a refugee travel document or emergency advance parole before departing the US, they may be unable, or before departing the US, if they don't receive it at a consulate overseas, they could be unable to enter the US, and they may be placed in removal proceedings upon entering to re-enter without this document. So it's very important. And just to note that traveling with a refugee travel document does not guarantee re-entry, just as it does not guarantee re-entry with advance parole. They're still going to be screened upon their attempted re-entry with that document for inadmissibility. However, CBP inspectors are advised to only inspect asylees returning with refugee travel documents for the grounds of inadmissibility that could result in the termination of their asylum. And then just to note that admission based on approved advance parole or refugee travel document, this would only come into play for a small segment of Afghan adjustment applicants based on asylum status who maybe entered the US without permission and then were placed into removal proceedings, and then proceedings were terminated. But if they do receive advance parole and then re-enter the US, they are now inspected and admitted. So when it comes time to applying for adjustment of status, they would not need to waive that with the I-602. Okay, so now we're going to take a look at the advance parole for SIV adjustment applicants. So unlike, as Sarah went over earlier, unlike the persons traveling on refugee travel documents, people who apply for advance parole based on a SIV adjustment are not limited in where they can travel. And they're not limited in traveling with their Afghan passport, since they're not technically availing themselves of the protections of their country where they claimed persecution, like asylees or those who granted refugee or asylee status. And so it wouldn't terminate the basis for their adjustment. And so they're not limited in the same way that people with asylum status are, and where they can go or whether or not they can use their Afghan passport. But if they have a pending asylum application or approved asylum application, some people can adjust based on both, as Sarah went over. It's still not a good idea to do so and travel with advance parole with the Afghan passport or with a refugee travel document, especially back to Afghanistan, for the same reasons that someone applying for asylum status or with approved asylum status should not do that. And then unlike asylees who apply for refugee travel documents and can retrieve the documents at a consulate abroad, so they just have to do their fingerprints and can go retrieve them abroad in order to re-enter the US, someone who's applying for SIV adjustment has to file the form I-131 and then wait for the approval before they depart the US. Otherwise, their I-485 is going to be deemed abandoned. And then like asylees who travel with refugee travel documents, remember that a grant of advance parole does not guarantee re-entry, even if they have it. So CBP inspects advance parole holders at the port of entry and has the discretion to find someone inadmissible or otherwise deny entry. And then just a quick note, under matter of Arabelli and Yarabelli, that the BIA held that travel for an adjustment applicant on advance parole does not constitute a departure, and so it would not trigger any unlawful presence bars that may apply to someone if they acquired more than 6 months of unlawful presence in the US. And then some of our Afghan clients who have TPS, just note that USCIS did apply this analysis to people with TPS. So if they travel with advance parole, it's not considered a departure for unlawful purposes either. Okay, so just a quick comparison. So advance parole, and this is for SIV adjustment applicants, the parole the advance parole document can be valid for up to 5 years. People are reporting that with the change to the EAD validity period that USCIS announced in September of last year, that they're also receiving advance parole documents that are valid up to 5 years. And then so advance parole for these individuals are issued on Form I-512L, and then they're used with and not instead of a passport, unlike the refugee travel document. And then again, you must wait for the approval before departing the US of the advance parole to avoid abandonment of the I-485. And then the refugee travel document, if you're an asylee or a refugee and you're not yet an LPR, you must have this to return to the US unless you have that emergency advance parole document. And they're issued on Form I-571, but they're only valid for 1 year and they can't be extended while outside of the US or otherwise. So many Afghan nationals may not have passports. And so since asylees should not travel with their passports anyways, if they do have them, refugee travel documents can be used in place of a passport. And as a general rule, they need the refugee travel document, but they can apply for emergency advance parole instead and travel with that. And we're going to discuss that process on the next slide. So both the advance parole or refugee travel document is applied for by filing Form I-131 with USCIS. There may or may not be a fee depending on when you're filing it, whether it's in conjunction with the I-485 and on what basis you're applying for the advance parole. So generally, a person with a pending SIV-based adjustment is going to be fee exempted. Afghan SIV-based adjustment is going to be fee exempted because their underlying I-485 is fee exempted, I think through September of this year, as Sarah said. So if applying before then and you file the I-131 while the I-485 is pending or with the 485, there's not going to be a fee. Otherwise, for these people, the filing fee is $575 and they're not eligible for a fee waiver, but there is no biometrics fee. And then an asylee or a refugee who files the I-485 also does not need to pay a filing fee for the I-131 if they file it with the I-485 or while the 485 is pending. Otherwise, it's the filing fee is $135 for an adult, and then there is a biometrics fee associated with that. And all this information is going to be on the I-131 instructions and including the filing fees. And then lastly, there is expedited processing available in very select certain situations if you can prove urgent humanitarian reasons. And then in the event of extremely urgent travel need, adjustment applicants and asylees, refugees may request an in-person appointment on the USCIS website with the new appointment website that they rolled out last year. To request an emergency advance parole document at a local USCIS field office. And with this appointment, people need to bring the completed I-131, as well as the filing fee if it's required for them, as well as evidence to support why it's an emergency and why they need this grant. Okay, so with that, here we have we've linked a couple helpful resources for you to take a look at while navigating this adjustment process for your clients. And we have about 2 minutes. I think we have some time just to answer a couple questions that might be in the Q&A that we weren't able to get to. We did have a lot of participants, so we were not able to get to every question today. So Liz, do you have any questions in there we want to answer?
We did answer 65 questions in the Q&A, so that's pretty good. We do have some open ones. I do see one question I saw people asking about was re-entry permits, which we didn't really talk about, which is, usually once a person has actually been granted LPR status, but the questions were about folks maybe who can't get Afghan passports. I don't know if you want to address that at all, Corey, or... I can.
So, yeah, like if they adjusted based on SIV
But they
adjustment, yeah,
can't need an Afghan passport, yeah.
yeah, I think they would be eligible to apply for a reentry permit and then use that in place of a passport.
Great, perfect. Okay. And then just confirming, I got a couple questions like this. Asylee with pending AOS receives a refugee travel document. They do not need regular advance parole.
Correct. Unless it's an emergency, they do qualify to go apply for an emergency advance parole document and can use that. But generally, the rule is they have to have the refugee travel document.
Perfect. All
I
right.
have a quick question for the group. We got this affiliate question. So essentially the question is, can an asylee with a refugee travel document travel to Pakistan and can they file for their visa to go to Pakistan prior with that refugee travel document? There's some conflicting information from the embassy website if they can e-file online for that visa. I don't know if anyone knows, but there are a lot of Afghans who want to go to Pakistan to visit family. Maybe not.
I don't know.
That's a good question to be
I don't know.
researched. Thank you. Thank you all so much.
Yeah. Thank
Okay,
you,
we got
everyone. Great questions by everyone. And I wish we could answer all of them, but I think this has been a great discussion. And I know I feel like I've learned a lot. So thank you to all my colleagues and thank you to all of you for doing this work and sharing your knowledge and your expertise in the field. We appreciate it. All right. Take care, everyone.